today's session, we're going to focus on equipping church leaders with knowledge and referencing tools to help in dealing with sexual abuse and understanding canon law in relation to that. Promote effective handling of abuse allegations in the aim of strengthening institutional integrity and our safeguarding culture. This is going to be framed within a theological, legal, and moral imperative to protect all, particularly the most vulnerable. We'll give an overview of Vos Estis Lux Mundi, aspects of the Penal Code, particularly its update in 2021, canonical processes and procedures, available support mechanisms, and focus on capacity building for accountability. Monsignor Daly, I'll hand over to you if you have anything else to add to today's session and our objectives, and we'll work through the slides.
Thank you very much, Danielle, for your introduction, and thanks for your kind words. So I think we'll just progress on with the slides. The canon law over the past 25 years has changed a great deal, and for many people it's a bit confusing about what the law is and what the procedures are. Canon law of its nature is pastoral. It has to be legal, and it is really important for protecting victims and all members of the faithful. As the sexual abuse crisis developed in North America, in 2001, Pope John Paul II issued Sacramentorum Sanctitatis Tutela, which is abbreviated as SST, and it in English upholding the sanctity of the sacraments. So in the church, we have a category of crimes classified as more grave crimes. There are other delicts, the canonical word for crimes, that are listed as part of Book 6 of the Code of Canon Law, from Canons 1311 to 1399. There have been a number of changes in Sacramentorum Sanctitatis Tutela since 2001. So there's been changed law, for example, to do with pornography, and during that time there's been changes over the age. Pope Francis in 2019 issued the first edition of Vos Estis
Recording in progress.
Mundi, You Are the Light of the World. And there it was for 3 years trial, and then in 2022 there was a second edition of Vos Estis Lux Mundi published. Pope Benedict had started the revision of Book 6 of the Code to do with penal law while he was Pope, and in 2021 Pope Francis published the finalised version of the revised Book 6. With these changes in law, there's also been a penal law user guide published by the Dicastery for Legislative Texts, and these documents will all be provided with links at the end of this webinar. Altogether, they want transparency, accountability, and justice for all. The changes in Book 6 include things such as now lay people are included in Canon 1398. So the penal law in the revised canon to do with sexual abuse of minors does include both religious and laity, and the changes in other canons, for example, to do with abuse of authority and ministry, would now be seen to include abuses such as priests' intrusive questioning in the sacrament of penance.
Monsignor Daly, is there also something of note with Vos Estis Lux Mundi in relation to the responsibility of which ordinary or bishop oversees the investigation?
Sure. The major change with the second edition of Vos Estis Lux Mundi is that in Article 3, the ordinary who receives the report about an allegation of abuse is to transmit it to the ordinary of the place where the events are said to have occurred. So wherever the events are said to have occurred, that ordinary, local ordinary, normally a diocesan bishop, is the one that's responsible in the first place for initiating and overseeing an allegation. Now, it could be in particular circumstances he hands it on to someone else because he has a conflict of interest. Maybe he was a classmate of the accused or something like that. But in the normal course of events, it's the local ordinary, usually a diocesan bishop of the alleged events, who carries out the investigation.
Yeah, wonderful. Just wondering also, in relation to the revised Book 6, in relation to lay people, and are they covered in the crimes?
Yes, they are covered in the crimes. So Canon 1398 states that, first of all, a cleric in paragraph 1 is to be punished with deprivation of office, possibly dismissal from the clerical state if he commits an offence against the Sixth Commandment with a minor. But in paragraph 2, a member of a religious institute or a society of apostolic life, like the Clubmans or a group like that, or any one of the faithful who enjoys a dignity or performs an office or function in the church. So if you have someone who's working in the diocesan youth team and they abuse a youth who's in a youth group somewhere, clearly they are committing a crime, and they can lose their job because they've committed a canonical crime.
Okay. Excellent. Wonderful.
Now, Vos Estis Lux Mundi really is a very important document. It was mandated globally by Pope Francis in 2019, and it applies to clergy, religious, and laity in leadership. So there is provision made concerning reporting of abuse, providing protection and care for alleged victims and complainants, and we do have quite a number of cases around the world where bishops or major superiors of religious institutes have not reported cases. They've covered up and they have enabled abusers to continue. So around the world in recent years, there's been a number of bishops removed in many countries because they haven't reported crimes of sexual abuse of minors to the doctrine of the faith. So from 2001, all ordinaries, whether they're local ordinaries like DOS and bishops or ordinaries, superiors of clerical institutes of consecrated life, they've been obliged to report to the doctrine of the faith every allegation they receive that seems to be true. So the complaint might relate to 1980, but if someone complains in 2005, it must be reported to the doctrine of the faith. And many religious superiors and bishops haven't been reporting those crimes, and Vos Estis Lux Mundi is holding them to account. And in the first place, when there are complaints about religious superiors failing to act, it's the responsibility of the metropolitan in the country or in the region of the church to investigate those allegations and report them to the competent dicastery. So it would often be the dicastery for bishops, but for mission territories, the dicastery for evangelization. If it's religious superiors, then it's the dicastery for religious and consecrated life. So there's a real effort to have transparency, accountability, and care of victims. So the Vos Estis Lux Mundi promotes a victim-centered approach, engaging with victims in a way that prioritizes listening, avoids re-traumatization by questioning them over and over again, and systematically focuses on their safety, their rights, well-being, expressed needs, and choices, like who they are complaining to.
So would you say that, so as well as providing, I guess, procedural guidance for investigations, particularly in relation to dealing with victims, that Vos Estis Lux Mundi has a clear shift from implicit to explicit accountability for the church authority, the ordinaries.
Sure. Yes, because things aren't just kept within the religious institute or within the diocese. The doctrine of the faith ensure that there's proper investigations taking place all over the world. So there's truly a one church approach, and that there is consistency in how perpetrators are dealt with. So punishments and actions taken truly fit what has been done.
Right.
And the document at the end of the synod last year made quite a lot of mention of the importance of accountability and transparency in all these matters.
Quite a significant shift, I guess, in the explicit nature of it.
Sure.
Might move to some canonical definitions specifically related to this.
Okay, so sexual abuse of a minor is contact or interaction between a minor and an adult when the minor is being used for sexual stimulation of the adult. So this can occur when there's direct sexual activity, but it can also be indirect. So when the Commission in New Zealand was hearing evidence, a victim gave evidence of how, as a child, she had to stand naked on a desk, and the brother masturbated. So there wasn't any physical contact between them, but it was clearly a sin against the Sixth Commandment and a crime of abuse. Sexual abuse also includes the use of child pornography, clergy and religious getting someone to send a topless picture, or them sending photographs of themselves. So it's quite wide. And when people buy pornography or they download it, they are cooperating in the crime, and so it wouldn't be happening if they didn't buy it. So they are definitely part of the abuse. There are many categories of vulnerable person, and the understanding of vulnerable people varies a great deal from culture to culture, and it's, I think, quite important that bishops' conferences define what vulnerable means in their cultural context. And there's certainly a lot of people who lack full freedom or protection, and they are easily taken advantage of. With grooming, that is clearly a major issue, and we see with grooming a pattern of behaviour aimed at engaging a child as a precursor to sexual abuse. So it includes establishing a special relationship. It also includes things like having a 13-year-old boy stay overnight at the presbytery. It's clearly a precursor to trouble. And some countries, like the Philippines, have laws civilly so that if a man is alone with a child in a hotel room or something like that, he's committed a crime. You don't have to prove anything happened.
Is there something more to say in relation to vulnerable persons, in particularly between the difference between vulnerability and the canon law definition that we might just be worthwhile clarifying?
Okay, well, there are vulnerable people, and when we're talking about them, we're talking about aged over 18. So the legislation to do with vulnerable people is really aimed at those 18 and over. So it could be people who have a disability, who suffer from a mental illness, they've experienced previous abuse, but all these things, there's a power imbalance. So a clergy person or a religious have spiritual power over people, and so they can then abuse that power. I remember a Bishop O'Connor in Canada being convicted of rape in a civil court in Canada over 30 years ago, and in that case it was held that his spiritual power over the Indian women on the reservation was the equivalent of physical force. So that's how a civil court interpreted it, and in general, the perception would be a priest has spiritual power over people, much like a doctor has power over patients, and that is then an abuse of power with someone who's vulnerable.
So, given that, is it appropriate for anyone for clergy, any clergy, to have a sexual relationship with anybody?
Well, clergy and religious shouldn't be having a sexual relationship with anyone, of course. And most of these activities that do happen do in fact involve an abuse of authority or ministry, as outlined in Canon 1378. So clergy and religious clearly often are manipulating people when they have these relationships. Hence, they're crimes.
Given our conversation now is focused on vulnerability, we do have a question in the chat asking that does it depend on the bishop's conference who falls into the category of vulnerable person, or is this universally defined?
Well, when you look at the universal guideline framework of the Pontifical Commission for Minors that has been published, they have a glossary, and a definition of a vulnerable adult there. But I'm very conscious that in different societies, the conditions of people vary a lot. There's a lot of cultural differences between countries and societies. And so in making decisions about these things, I think we have to take into account the context. So, for example, someone comes to New Zealand as an international student, clearly they're vulnerable in a way other students in New Zealand aren't vulnerable, and it's different to being in their home country.
We might look at some of the key provisions of Vos Estis Lux Mundi now,
Sure.
specifically turning initially to reporting requirements, particularly what's mandatory.
So Vos Estis Lux Mundi introduced mandatory reporting. Now, the mandatory reporting applies to the external forum. It does not include internal forum matters, which Vos Estis explained as being involving the seal of confession and spiritual direction. Mandatory reporting applies to clergy and religious. So when clergy or religious suspect or have good reason to believe abuse is happening, then they are required to report it. So an example to me would be if you have a sister and maybe she's at a relative's funeral and she goes out to the sacristy and to check on the reading, she sees the priest fondling an altar server, and if she doesn't report it, clearly that priest could go on to abuse other people. So because sexual abuse is against everything the church stands for, clergy and religious are required to report it.
So I think it just might be, oh, sorry, Monsignor, I just wanted to say, I think it might be really important just to put an exclamation point that it's not dependent on the civil requirement, it's a canonical obligation.
Sure. And so it's if you love the church, you will report abuse, which is doing so much to damage victims and which is doing so much to affect the credibility of the church. We have to ensure the church is a safe place, and a safe church is a credible church. And lay people who work for the church should be required in their employment contracts to also be reporting abuse they suspect or know is happening. And some of the offending clearly includes lay office holders. So I mentioned earlier a youth worker and a youth, but we've seen in recent years Luis Figari from Peru, who was the founder of that Institute of Christian Life, he was clearly a terrible abuser, and he struggled. People struggled to bring him to account. The mandatory reporting is also backed up by changes in Book 6 of the Code, because in Canon 1371, paragraph 6, there is provision to penalise people who, as clergy and religious, are covering up or failing to report abuse. It could also relate to superiors who are not cooperating with investigations, and maybe even tell members of their religious institute not to cooperate with investigations.
Can you just clarify the difference between external and internal reporting channels, and also if there are any exclusions, particularly in relation to the sacrament of penance?
An internal reporting channel would be a priest doing something like perhaps getting someone pregnant, and then with her getting an abortion, he's incurring an automatic excommunication. He's irregular for the exercise of ministry, which means he can't function. So if it's secret, he would have to deal with the apostolic penitentiary in Rome about his situation. So that's internal. But external reporting channels, that is reporting to the local ordinary, to the doctrine of the faith, perhaps something that relates to the dicastery for bishops or religious. The external reporting concerns external events that are seen that don't have any relationship to ministry in the internal forum. But if someone experiences abusive behaviour in relation to confession and the sacrament of penance, they can always report that in the external forum to the bishop, and we really want them to do so.
Before we move on, just wanted to respond to a question that we have relating to if a cleric has a consensual sexual relationship with another adult, is this a canonical delict or just a breach of their vows?
I would say it's a delict, a crime, because regardless of anything else, it's an abuse of his position and authority. So I guess if a priest went to a brothel, he pays for sex. But when you have a priest and a parishioner, it's no different to a doctor and a patient. The priest is abusing his position. He's supposed to provide spiritual care for people, and he and instead of providing pastoral care, he's using someone for his sexual gratification. He's not committed to that person. It's clearly a crime. Priests have in the past liked to talk about it as a consenting adult relationship. In fact, there isn't such a thing. It's always going to somehow involve abuse of his authority, position, or spiritual ministry.
We do have quite a few questions around this, and I think that we might need to come back to this at our Q&A component of the session and keep moving on. But I just think we might just respond to one more because it's quite permanent. If in relation to reporting and the obligation to report, in the context of a historical case, if the victim was not defined as a vulnerable adult in canon law and does not want to report it, is there still an obligation to report that, given what you've just said about your view of it being idyllic?
Yes, I think there is an obligation to report. For one thing, the church needs to ensure that the perpetrator doesn't do it again. So it's really important that there are safety plans, there's supervision, there's counselling, that everything is done to stop the original perpetrator doing it again. So that's really important, and the victim, him or herself, needs to be cared for and looked after depending on the circumstances of their case.
Wonderful. We'll come back to some of these questions, but just for flow, we might move on to the expanded accountability measures that are related to this.
Okay, so we clearly have bishops and provincials, major superiors of clerical religious institutes, provincials of especially brothers who are subject to investigation because they've failed to report, they've failed to act on abuse. This oversight comes from the Metropolitan. If he's accused, then it's the senior suffragan bishop in the country or the province who's going to oversee the investigation of the Metropolitan. Lay people who hold offices in the church are held to account, because we've clearly got lots of allegations related to schools, orphanages, etc. The reporting of complaints also includes anonymous complaints. Now, they're not ideal, but sometimes it's so obvious that the complaint is true that it really has to be handled. So if the complaint comes in, for example, I have had a family complain to me about a 13-year-old boy staying at the presbytery the previous Saturday night, and then they didn't want to make the complaint themselves because they feared retribution in the community. So I took the complaint and handed it on anonymously. Then the bishop dealt with the priest in a minimal way. The next Sunday at Mass, the priest during the homily attacked who dobbed him in. So sometimes people may have good reason to hand in complaints anonymously. If a photograph comes in of a priest and a woman in the sand dunes at the beach, it may be pretty obvious that something has to be done. So there's only a photograph, but the bishop can't do nothing. If someone sends in a letter saying that it's unsigned, but it's saying that at 9 o'clock last Friday night, the priest went into the brothel at such and such an address, it's so detailed and specific, clearly it's got a lot of indications it's going to be true.
Now, I just wanted to clarify, we do have a question that if someone's in a country or a jurisdiction where the age of a minor is 16, is it true that actually has no bearing on the canonical perspective of this because it's anyone under the age of 18 in canon law? Is that correct?
Yes, that is correct. So essentially, I've been talking to priests in a country, and the priests have said to me at question time that the age of consent in our country is 16. Why are you making a deal of sex with anyone under 18? Now, clearly, priests shouldn't be having sex with anybody. So, first of all, now, the priest and a 17-year-old may not be a civil crime in that country, but it's certainly a more grave crime in canon law. And if the person is aged 18, it won't be a more grave crime, but it'll certainly be a crime in canon law.
I think as we're talking about reporting, and particularly you mentioned an example of retaliation, what protections are there for victims and whistleblowers in canon law?
Bishops and all church leaders are meant to ensure protection for victims and people who complain. And it's an obligation on the part of bishops and church leaders in general to ensure that victims are protected and supported. Now, if a priest somehow, who's accused, somehow violates the privacy and the protection of victims, then it's a requirement for the bishop or the church leader to take punitive action against the priest and stop that happening. So, for example, if you get an accused priest and then he starts a petition saying that he's innocent. That's the kind of thing that's totally unacceptable. So there is a Canon 1722 which enables a bishop to prohibit the accused priest from exercising sacred ministry, can require him to live in another place, so he no longer has the potential for meeting the complainant in the supermarket, has no contact with the complainant's family. And that can be applied at any stage for allegations involving a more grave crime like abuse of minors or absolution of an accomplice in a sin against the sixth commandment or any sexual activity related to confession. For other crimes, for example, an adult complaining about adult sexual contact, Canon 392, as interpreted by the Dicastery for Legislative Texts, enables the bishop to apply the same measures at any time from when an allegation is first received. So it's the obligation in dioceses where there's safeguarding officers to ensure that there are safety plans in place, that whatever measures are necessary are taken to protect victims. And I guess it could also come if the accused was silly to have civil law protection orders in place.
Before we move on, I just feel if you wouldn't mind commenting on the difference between, at this point particularly, and the restriction or the prohibition of exercising ministry in relation to the difference between that we are risk and managing risk and the importance of those safety plans in doing so versus actually determining guilt, and how that at this stage it's not about guilt, it's simply about managing the risk.
Well, the canon does not talk about managing the risk. The canon talks about preventing. Canon 1722 talks about preventing scandal, protecting the freedom of witnesses, and safeguarding the course of justice. Now, risk could come into those categories in a number of ways, but when a priest is put on administrative leave, when there's a serious crime that's been alleged, it would cause scandal if the priest was not on some kind of administrative leave. So the general expectation in society is if a teacher's accused of something with a pupil, he or she'll be on administrative leave. The freedom of witnesses has to be always protected, and safeguarding the course of justice does involve risk in some cases. So they're broad categories, and I think the bishop has freedom to really protect victims and further potential victims.
We might move to cooperating with civil authorities as we finish this section of the session.
So cooperating with civil authorities is important. So Vos Estis Lux Mundi requires clergy and religious to obey civil reporting laws. And it's a crime in canon law not to obey those civil reporting laws, except where the internal forum is involved. So unless it's something that involves confession or, as Vos Estis Lux Mundi pointed out, spiritual direction, the clear obligation is for clergy and religious to obey those reporting laws, to hand over church documents when they're subpoenaed. Church leaders are not to obstruct investigations, whether they're civil or canonical. And it's clear this has been a major failing in the Catholic Church in recent decades, and it's now clearly a matter of a crime in canon law now, and we're seeing many bishops removed because they've failed in their obligations. There is dual compliance. Civil law can put a convicted priest in jail. Only canon law can dismiss him from the clerical state. So often there's going to need to be action both civilly and canonically, and some of these crimes will involve financial crimes as well, and then the evidence in civil law cases will be useful for us to convict the priest who's also been engaging in sexual crimes and misconduct.
So we might just focus now on the penal code updates, particularly in Book 6, as we start towards the tail end of the session and focus on some of the question and answers shortly.
With the revisions of Book 6 of the Code, Pope Francis changed 63 of 89 canons. So it was a very dramatic revision of Book 6 of the Code of Canon Law. Now, one of the major changes concerns Canon 1398. Previously, it had been Canon 1395, and sexual abuse of minors was seen as a violation of the cleric's obligations to continence, abstaining from sex, and celibacy, not marrying. And the Australian Royal Commission and others were very critical of this. So there was a mentality that saw abuse of minors and vulnerable people as a moral fault, and religious leaders were not seeing it for what it was, as a more grave crime. So the Canon on abuse of minors became the new Canon 1398. It also included with minors those who habitually lack the use of reason. Vulnerable person crimes are not reserved to the dicastery for the doctrine of the faith. Grooming offences are also not reserved there. But if a priest engages in some pornography with someone under age 18, that is a more grave crime. Other pornography with adults, like grooming and vulnerable persons in general, have to be dealt with in the local diocese. If you have someone who's a priest and he's a serial offender with one person or with multiple people, he has to be warned. There has to be due process following the revised Canon 1339, but such a priest can be dismissed from the clerical state by a trial, depending on the offences, or by the use of the special faculties which were given to the dicastery for evangelization and the dicastery for clergy in 2008 and 2009. When there is a case of a religious that's a brother or sister who abuses minors, the local ordinary, normally the DOS and bishop, where the alleged events took place, carries out the investigation. But once that investigation has been concluded, it's over to the bishop then to make a decision and then to send the case to the Superior General of the Religious Institute, and following their constitutions, the law for that religious institute, then it's over to the superior then to dismiss the religious from the religious institute or not. Now, if the religious institute doesn't, against the recommendation of the bishop, then the case is going to have to be dealt with at the level of the dicastery for religious and consecrated life. Sometimes these matters involve degrees of offences, and clearly there's a major difference between imposing a kiss on a minor, someone under 18, and having sexual intercourse with a minor. So both are offences against a minor and are more grave crimes, but the penalties are very obviously going to be different.
Just briefly wondering if we might speak to the accountability for failing to act.
So Canon 1371 makes provision for someone failing to report to be punished. So that canon says a person who neglects to report an offence when required to do so by a canonical law is to be punished according to the provision of Canon 1336, paragraphs 2 to 4, with the addition of other penalties according to the gravity of the offence. So clearly, if it's a crime of abuse of minors, the bishop fails to report it, and particularly when it's giving scandal, the bishop is going to find himself out of a job. So that's happening in many countries. With the revisions of Book 6 of the Code, there were a number of changes made in Canon 1339. And so with these additional paragraphs added to this canon, it's really important when there is a case of allegations that seem to be true of sexual abuse with adults, it's most important that the bishop and or the religious superior puts in writing a warning to that priest or religious that if they do something like that again, then serious action will be taken against them, which may include dismissal. So paragraph 3 of Canon 1339 says the fact that there's been a warning or a correction must always be proven from a document. So the bishop, let's say, sees this priest, he gives him the warning verbally, talks to him, takes various safety measures, but he must give it in writing to him the consequences if he misbehaves again. So there are certainly priests who have been warned and then they've engaged in a sexual relationship with another woman, and then they have been tried and dismissed from the clerical state. When people abuse authority, they should be receive extra penalties. So it's obviously much worse for a bishop to have a sexual relationship with someone than it is for a priest.
Let's move on to some practical processes here, particularly in relation to reporting. We've got a little bit of a flowchart, a process flowchart here, if you might just step through each of these points for everyone.
In every diocese, it needs to be really clear who receives reports or allegations, and there needs to be a public process that's available so that people know their rights and they know who to go to. In a lot of countries, there are people like a victim assistance coordinator, and that kind of a person provides support, ensures legal representation and advice, because most people have no idea about canonical processes, the differences between a sexual relationship with a 17-year-old and an 18-year-old, things to do with internal forum. Once the bishop of where the alleged events occurred receives the report, he needs to be making some kind of initial decisions about whether it seems to be true or not. So it could be that the priest accused is dead. He's had many victims in the past, and the bishop may see there's no need to have too much of an investigation in this particular case. It really just needs to be established the victim was in the same parish at the same time as the priest, and the circumstantial things are the same. Because the priest is dead, there may be a decision to have compensation. But in most ordinary cases, there's going to need to be a preliminary investigation. So that's following Canon 1717 and following. So there needs to be some kind of investigation, filling in the doctrine of the faith fact sheet at the end of the Vade Mecum, so the basic facts are clear. It's the person who's complained is going to need to be fully investigated by someone who's competent. As much as possible, we want to avoid re-interviewing, re-traumatizing complainants. And once that's done, then a decision needs to be made about whether the accused is notified and interviewed if he's prepared to be. There's decisions to be made around that. In some cases, maybe involving the sacrament of penance, it may not be wise to go to interview him because there's very little he can be asked, and it may be best to close the investigation if it seems to be true and report it to the doctrine of the faith for their guidance and direction. Even if the bishop thinks it's not true at the end of the preliminary investigation, if it involves a more grave crime, like a minor or the sacrament of penance, he must report it to the doctrine of the faith. So that's a fundamental requirement. And in the third session, we will talk about extrajudicial process or trial. and that's where their real investigation should take place. There needs to be transparency, and people need to know who to go to and what to do. When there's secrecy and everything is hidden, that only enhances vulnerability and cover-ups.
I just wanted to make a note. We did say that we would run for 90 minutes. There are a lot of questions that I feel are very important to try and circle back to. So just to let everyone know that we'll go through the remainder of the slides, but we will spend some time working through these questions at the end.
So anonymous cases aren't ideal, but they have to be dealt with. Historical cases, even if they happened a long time ago, if they're reported after 2001, then they must be reported to the doctrine of the faith. Around the world, there's lots of issues about clericalism. Clerics have been favoured, held on a pedestal. People fear they're reporting about someone more powerful than them. So education needs to happen. Clergy are not superior to lay people. Clergy have to be held to account if they offend. We have to educate around cultural denial or cover-up. It's really important that bishops keep good records, because there can be something come in today and not much can be done about it because it's lacking in detail. But when another complainant or two comes in, then the whole equation is changed, and it's one complaint backs up another.
Might look at some, in our last couple of slides, just some local canonical safeguards, and then we might move to some of the questions.
Sure. So all bishops' conferences are required to have protocols. There needs to be diocesan norms implemented. Clergy, religious have to be educated, as do diocesan employees and volunteers. There's got to be clear expectations of people so they're competent to recognise the symptoms of abuse and they do something about it. Protocols have to be published. There's no good a country having a protocol and then not publishing it. That's completely contrary to the Church's law on these matters. And when we have safeguarding, it's not just dealing with offences, but we've got to do everything possible to ensure the church is a safe place, that there are procedures in place so that people are protected, they are alert, and everything is done to ensure minors and vulnerable and all people are safe. clericalism is an issue that Pope Francis attacked a lot. Pope Leo has also indicated his opposition to it. So leadership has to be service-based. There's got to be transparent decision-making. We know that in the past, if decisions about returning abusive clergy to ministry were made by a committee of mothers, the clergy would never have been returned to ministry. So it's really important, as synodality is promoted, that there is transparency, accountability, that lay people are involved in decision making, and those who do things are trained in trauma informed practice. Okay, thank you very much for listening.
Thanks.
We'll now move to the question and answer session.
Yes, and we understand that people may have obligations and need to leave, but we will continue on and answer as many of these questions as we can. I'll just make a note that we will be sending out an email to people in the coming days to provide information about how to register for the upcoming sessions, as well as links to the resources that accompany this session. And I've also just popped in the chat for everyone a link for the session evaluation, but we'll also include that in the email. Brendan, I just wonder, there's been a few questions focusing on spiritual direction, and if abuse is shared during spiritual direction, what is the obligation of the spiritual director? And if you could provide a little bit of context around hearing abuse in that context.
I think with spiritual direction, there are people who are abusers and people who are victims. So I think that there's clearly some different issues for both categories of people. I think if someone is providing spiritual direction to someone who's a victim, one of the first things that would crop up to me is how competent is the spiritual director to be managing everything in relation to the victim. So the spiritual director is assisting someone, particularly in their relationship to God and other people. And if the person who's the directee has got major issues or baggage or damage related to abuse, the spiritual director needs to ensure the directee is referred to a psychologist or someone competent to help them. So I think care for that victim is the top priority. Now, also clearly the victim should be encouraged to report it to church authorities. Now, all these things have to be managed according to the circumstances and the state of mind and the situation of the victim. So it may not all happen instantly. When a directee is guilty of abuse, then there are questions about should this person be in ministry. They obviously need to be getting help. So the spiritual director has to promote and push these things. Now, if the spiritual director is in a seminary or for a novitiate, clearly he can't break the confidentiality with this person who's seeing him. But if the directee will not take direction from the spiritual director, so maybe the spiritual director is pushing that he leave the seminary or something like that, then at the end of the day, the spiritual director can't reveal what's going on, but the spiritual director can refuse to be a spiritual director anymore and make that kind of statement.
We have a couple of questions that relate to reporting to civil authorities and particularly police, and just wanting to clarify that we're not suggesting that people don't report abuses of clergy to the civil authorities or police, but simply that there is also an obligation to report to the church. Is that correct, or anything you want to elaborate on that one?
I think it's important that where there are crimes involved, the victim should be, or alleged victim should be encouraged to report to the police. Now, if the person's an adult and they decide not to, well, at the end of the day, that's their decision and has to be respected. But when someone is still currently a minor, then that does change the equation, and there may well be an obligation on the church authority to go to the police.
Yeah. Just wondering if you might want to comment on a two-part question around supporting someone if they've made a report about allegations and at the bishop's conference level, there's no response. Can bishops be charged by the allegation of hindering the investigation of a case if there's cover-up of cases, or simply moving an alleged perpetrator to another jurisdiction and not responding to the actual allegation?
If someone doesn't get a response from their bishop or the bishop's conference, they should be going to the apostolic nuncio in their country, and they can go directly to the doctrine of the faith in Rome. So I've certainly seen cases in Asia where a bishop hasn't acted and the complainant has got help from religious to go direct to the doctrine of the faith. So that's always an option, but probably the easiest is going to the nuncio in the country if the bishop is not acting.
Right. And I think we're going to tackle this in the next session and then in session 3 as well. But is it correct that the church needs to wait for any civil process to conclude before initiating the canonical process?
It depends on the circumstances. I've certainly experienced where an allegation was made to the police and to the bishop, and then the police in this country said, like, we're 3 or 4 years behind dealing with historic cases, so you may as well go ahead and deal with it. So, and that in fact has been what's happened. Now, this particular case didn't involve minors, it was adult offences, but it did get into the area of more grave crimes. So in actual fact, the chances of the police laying charges were slims, and nothing's happened since the church process ended.
Maybe a quick one. Is it only sexual abuse that's considered a delict, or what about other forms of abuse, particularly psychological or verbal abuse or things of that nature?
They don't constitute more grave crimes. There are certainly crimes that involve financial and abuse particularly, but where we have particularly a priest abusing his authority or his ministry, he may well be committing a crime under Canon 1378 by the way he's manipulating or oppressing a particular individual member of the faithful.
Right. We have a question from the chat that is just asking for your opinion in relation to what does the fact that the bona protection in relation to abuse refer to the life, liberty and dignity of the person have on a judge? And so how will the perspective of justice evolve, in your view, after the reform of Book 6 in structural terms?
I think there is discussion going on at present about adding a paragraph to do with spiritual abuse to Book 6. So Pope Francis had asked the Dicastery for Legislative Texts to work on this. So presumably that's still going to happen with Pope Leo, and that's clearly going to broaden the understanding of abuse of authority and ministry. There have been quite a number of notorious acts of spiritual abuse involving artists and other people, so they're going to clearly be more clearly encompassed by future legislation.
Okay. Is there any specific timeframes noted in which allegations once made to, in this case, the question refers to the religious superior, should be investigated and concluded? Do we have timeframes or guidance around this process?
No, we don't. So I think if there are issues about failure to act, I think they just simply have to go in. The reality is they can't be too old because religious superiors tend to be senior people anyway. And so if it's more than 20 years ago, they're liable to be dead now if a complaint comes in.
And as far as the process, once a complaint's been received, is there guidance around how long that process should take from receiving an allegation to actually undertaking the process to respond?
Well, that's just all meant to happen as quickly as possible. But when it seems to me that where you get grievous cases now, they get acted upon reasonably quickly. So the Cardinal McCarrick case was kind of a watershed moment in the church, and since his case, the Holy See seems to be moving much more quickly.
We have quite a few questions that relate to the same theme around, people asking for guidance or advice if, whether it be the local bishop or indeed the bishops' conference in the country where they are, don't seem to respond proactively or don't promote safeguarding and their procedures and essentially what guidance or advice would you have for people who are getting roadblocks in raising issues within their local church and actively being hindered in the process by the hierarchy in their jurisdiction?
Perhaps they could be in contact with the Commission for Minors. Is that an appropriate answer? If it's things to do with more grave crimes, then I think they must go to the Dicastery for the Doctrine of the Faith. And there's always the option of going through the nunciature in the country, but things can be sent direct to the Vatican. So if something goes to the Dicastery for the Doctrine of the Faith at the Vatican, it's going to get there eventually.
Yeah. There's, and I think we might have tackled this, but specifically there's a question about Canon 1398 and wondering, is there a prescribed period in reporting abuses of minors or vulnerable adults of clergy?
Well, the vulnerable adults is really a complaint that's going to be going to the local bishop. When people are abused as minors, so they're under age 18 when something happened, they have 20 years from reaching the age of majority, so that's 18. So they've got till age 38 to complain. It is possible if people complain after that time that there will be what's technically called derogation from prescription, which basically means prescription, or which is not exactly, but the church's equivalent of statute of limitations. There'll be a decision made, it doesn't apply. So practically speaking, people can complain regardless of how long ago it was. Pope Francis was always in favour of derogating from prescription for abuse of minors, and I would be assuming that policy still stands.
And your opinion, if the accused is deceased, should that still be reported? Historical cases?
Well, I think it's helpful for the dicastery for the doctrine of the faith to know what cases are around, or because they certainly have a lot of figures about when abuse happened, because clearly there was a lot more in the 1980s than there is in the 2020s. But practically speaking, once you've got an alleged offender dead, you can't have a trial, you can't get moral certainty, and really a decision has to be made about care of the victim and probably compensation, etc. That has to be done on a lesser standard of proof.
Yeah, it's always a difficulty when the accused is no longer with us.
Yep.
There is another question that relates to the internal forum. What is your guidance where, if civil law requires reporting, and Dalm instructs us to follow civil law, what should the director do in this case? What's your guidance on how to proceed in a situation like this?
I think a possible way forward might be, in some cases, that the priest gets the young person to see him again outside confession. Then what is said outside confession does not have the secrecy of the seal of confession. So what's said in confession is and always remains under the seal, but if the person tells the priest outside the confession what happened, then the priest can be in much more of a position to help. But the first port of call, I would think, would be get the young person to talk to parents, a teacher, someone else to help them. But the priest has got to manage it as best he can. It doesn't occur very often, but the young person needs to be able to be helped. And of course, it mightn't always involve clergy, because the most likely thing is a young person is talking about a stepfather or something like that. And then the possibility of going to a parent mightn't be so simple, and then there may have to be some careful approach to handling it outside the confessional.
Yeah. In canon, this is from a perspective of canon law. Is young people in formation, whether that be for religious life or the priesthood, are they considered vulnerable adults in canon law?
I would say they could be considered as vulnerable. That's not going to make it a more grave crime, but I can think of a case last year where a seminary rector of a minor seminary was dismissed from the clerical state because he had been abusing seminarians. And of course, that Cardinal McCarrick case certainly involved seminarians, but he was abused. He was dismissed for other crimes.
Just in relation to undertaking an investigation, or particularly preliminary investigation, should this be conducted by an independent person to ensure impartiality? Who can conduct the investigation? And I think it might be important, I know we're going to go into more detail in our next session, but just to consider preliminary investigations and then separately a canonical process.
Okay. I think Canon 1717 allows the bishop to appoint a delegate to do it. Now, I think the bishop would be extremely unwise to carry out the preliminary investigation himself, or a lot of these things, because he has a conflict of interest in many ways. Canon 384 requires him to uphold the rights of priests. Canon 383 gives him all kinds of obligations towards the faithful in the diocese, which would include victims or alleged victims. And how can the bishop carry out these roles and then make a decision about someone's guilt or innocence? That there's just far too many conflicts for a bishop to do that, and royal commissions or other similar bodies around the world are making many criticisms of bishops being judge and executioner and everything else, because they simply have too many irons in the fire.
In relation to the process, the canonical process, is there allowance to receive feedback from victims on the progress of their complaint? Is that something that's stipulated?
Well, in any procedures, it's really important that the alleged victim or complainant is kept informed about the process and what's going on. Now, most people in the church don't understand canonical penal processes, and victims are going to be just as much in ignorance as everyone else. So they do need advice and help all the way. They need to be kept informed about what's going on, and there are decisions they can be making that do impact on their rights. So it's really important that they are properly advised and helped. And so as the law is at present, the accused priest or religious must have a canonical advocate, but the alleged victim doesn't. And it's something that's clearly a major shortcoming in the universal law.
There is a question here that is a little bit challenging. If the perpetrator compensates the victim and the family of the victim accepts the compensation and does not want to report the incident, what should the bishop or the superior do?
The bishop or the superior do have the reality that this priest has committed a crime, and maybe a more grave crime. Now, that means that that priest is probably not fit for ministry. The fact that the family have accepted some payment doesn't the priest might be able to do it in that cultural context, but effectively that young woman who got pregnant has had her life changed. So her choice of who she marries is dramatically changed. She may in fact not be able to marry. So what the priest has done to get rid of the complaint may be completely unsatisfactory. So, for example, I can think of a case like that in a particular country. So there was some kind of payment settlement from the priest to the girl's family, but that girl ended up having a mental breakdown. She's really going to be poverty stricken for the rest of her life. The bishop can't be tolerating such an injustice. It's a clear example of clericalism, and that sort of action should not be tolerated.
We have 6 questions left, and we might try and finish these 6 up as we approach 2 hours. What are the requirements? Are there any requirements for publicizing the reasons or any explanation for the removal of faculties or placing a cleric on administrative leave, or relocating to another community? Is there any obligations to inform the local superior or the ordinary of that location, or indeed make any of the reasonings known outside of the accused in this case?
I think the church has to be really careful what it says about any accusation, because under Canon 220, people have a right to privacy and their good reputation. So once you've got something on the internet, then you can't take it down. So once something's on the internet, for example, about a priest breaking up a marriage, how do you get that off the internet? Or if something's put in the parish bulletin about the priest being on administrative leave or some description like that, practically speaking, it's there, and whatever the outcome of his case is, it's a problem. And then when people know about who a complainant is, that may lead to actions against them, because I can think of a woman who complains and then parishioners shove her when she's leaving the church after Mass. So the church has to be really careful about what's said, and it's a major problem in justice for all concerned about how these things are handled.
I think this is a question about your, what your thoughts are. Some religious orders have published lists on websites of those who have been credibly accused and convicted. Is this something that should be done more widely?
No, the Holy See has been opposing publishing these lists because, for a start off, the lists have been compiled without proof, with moral certainty, the Church's standard, which is close to beyond reasonable doubt. So probability is not a good enough reason to effectively destroy someone's reputation.
So there's a question asking for clarification around if a child reports abuse but does not wish the case to be reported to police, the confidant in this case, or the person receiving that allegation or that disclosure, in this case from the child within the church, is still obligated to report this to police because they are a minor?
Well, that would be the case in many jurisdictions. So that's something that's got to go with the civil law in a country. But the general position of the church in documents like the penal law user guide, I'm pretty sure it's in there, but in Vos Estis, and I think the DDF Vademecum, there's an encouragement for church leaders to report abuse to civil authorities, whether they're required to or not.
Yep. I think that's good practice. There's a question that relates to Canon 1311 and then also 1341, asking how they should be interpreted in terms of the purpose of the sanctions. Do these new orders, namely the restoration of justice or the reform of the offender and the repair of scandal, have any implications on how the purpose of these sanctions must be understood?
Well, it depends on the case and the individual perpetrator, but it's obvious that when a penalty is imposed, one of the things we want is for the offender to reform, to be helped so that they stop offending and they don't do it again. There's clearly scandal with some of these major crimes. Therefore, offenders have to be dealt with appropriately, and the victim has to have a sense of justice, or receiving justice. So they're all going to want it ensured that the offender doesn't offend again, but they have to be vindicated. Someone has to pay some kind of penalty because of the injustice that they've experienced and the harm that's come to them.
We've got 3 questions left. One asks for a comment or a question about negligence. Is that also defined as abuse?
Well, negligence may be abuse. So when someone is harmed by failure to act, then that is most likely to be because of negligence. So Canon 1321 says in paragraph 2, no one can be punished unless the commission by him or her of an external violation of a law or precept is gravely imputable by reason of malice or culpability. Paragraph 3 is talking about the omission of due diligence. So clearly we have serial offenders. If a bishop fails to act, allows someone to continue in ministry, he hasn't done anything to abuse the new victim, but his negligence has enabled it to happen. That bishop is responsible. If the bishop doesn't do what he's required to do and report the case to the doctrine of the faith, he's negligent. And there's also a requirement with Canon 128 that people have a right when they're harmed by negligence to be compensated for that.
I guess there's a comment with a question in relation to where the perpetrator is already dead. How can justice to the victim be administered? Is there any provisions in canon law for this situation?
It's up to the local ordinary, or I guess the religious ordinary, to deal with the situation as best they can. It's up to the local church or the religious institute to manage it. Clearly, someone may need counselling and help, and then often these things come down to payment of money after that, and the bishop or the religious superior apologising, etc.
So I guess there's a question relating to where there's been a matter settled amicably before a canonical decision has been imposed, and the victim withdraws that complaint. Will the investigation still go ahead if the victim actually withdraws their complaint midway through the process?
Well, it depends on the situation. So you can easily have a victim complains, then they're interviewed in the preliminary investigation. It goes to the doctrine of the faith. They see the potential that a more grave crime has been committed. Then you get into an extrajudicial process. The victim won't have any more to do with the church or the case, but it can still go ahead on the basis of their original statement, and the offending priest can still be dismissed from the clerical state, even though the victim won't be re-interviewed again. So that, in my experience, that happens a number of times.
We have one question. I'm just going to pick up a point of clarification from the chat, and then we might finish with the final question. Just a question in relation to the Eastern churches and the reporting regarding bishops in Valm. Is there a comment about this not being the metropolitan and the equivalent? Is that the major archiepiscopal?
Yeah, the eparch. Yes. So when a case involves the Eastern churches, then like if it's a cleric, it's still going and a minor, it's going to end up at the dicastery for the doctrine of the faith. But the dicastery for Eastern churches would provide guidance and direction about these matters if there's any doubt, and they're competent for adult matters in relation to the 23 Oriental churches.
Wonderful, thank you. The last question, circling back to the comment about negligence and asking what implications there may be for lay religious who are negligent in reporting, both within the institute and in relation to the diocese.
I think the religious institute is liable for its members. Now, the religious institute is obviously engaged in pastoral work, pastoral activity, and so any of that work or activity comes under the diocesan bishop. He's the one who's going to be carrying out the investigation. If there's a superior in this religious institute who's failed, then it's going to come under vos estis. He's the religious is the superior under Article 6, and he can be held to account, removed from office, whatever.
We have gone a little bit over, but I feel like, as we both agreed, that it was important to try and respond to as many questions as we can. We still have quite a number of people that have stayed on, so I think it was worthwhile.
Sure.
Thank you, Monsignor Daly. I think that was really worthwhile. I do encourage everyone to please complete the short evaluation. That will be very helpful to us to understand how we can improve this in the future. And also, what other topics might be of relevance and importance to address in future sessions. But for now, thank you, everyone. Thank you, Brendan. We'll see you next week. And
Sure.
and God bless.
Yep. Thank you very much, everyone. Thanks for listening.